Man with Big Man Law here in Jackson, Mississippi. Welcome to a little bit of vice and a lot of advice with Big Man Law. I'm just drinking on some Basil Hayden's straight Kentucky bourbon whiskey. It's something I was introduced to in law school, and it has remained one of my favorites over the years, and gotta actually enjoy it for it to be a vice, right? I'm here to talk about beating a DUI in Mississippi. Mississippi DUI carries a lot of bite, up to 48 hours in jail. Loss of your license for 120 days can really screw somebody over. We're talking about the guy that went to the beer barn and had 2 or 3 beers before riding home at 5:30 in the afternoon a lot of times. How do you beat a DUI in Mississippi? The first thing I tell folks, heck no, don't blow. Do not blow into anything. The portable breath test is where they bring it up to you at the side of your car and say, hey, blow into this real quick. If it doesn't register anything, I'll let you go. It's not necessarily true. If it don't register anything, they're just going to keep going down the road, probably start looking at the drug avenue or something like that. Now, the portable breath test that I just talked about, though, is not what really matters. That's inadmissible in court for anything other than to show it had a positive or negative readout for the presence of alcohol. What really matters is the Intoxilizer 8000 that you blow into at the station most of the time. There's some SUVs that keep it riding around in the back end. By far and large, you're going to find it sitting back at the station and at the Gray Bar Motel. So we are not going to blow into anything. That is critical. Mississippi has what they call a per se DUI. And what that means is the second you hit that .08 mark and you blow in that Intoxilizer 8000 down at the station, you're presumed impaired under the law. So that's the first hurdle you'd have to get over is the Intoxilizer. And if you never blew, you don't have anything to get over. So heck no, don't blow. Keep that in mind, folks. The second thing goes along with that. Don't do field sobriety testing. Standardized field sobriety testing come around in the 1970s with the National Highway Traffic Safety Administration. These tests are terrible tests. It's a battery of 3 tests: the horizontal gaze nystagmus, the walk and turn test, and the one-leg stand test. Now, the horizontal gaze nystagmus is the one where they go back and forth that you see on the videos a lot of times. The walk and turn test is just that. You walk 9 steps, not 10, that's key to know. And you do a really, really wonky turn and walk 9 steps back. And the one-leg stand test is just that. You stand on one leg. I have done these tests at continuing legal education seminars. I've seen attorneys do these tests. They're not designed for you to pass. You damn near have to be an athlete to pass them, and even some athletes fail them. Don't do the field sobriety test. If you don't do the field sobriety test and you haven't blown into the machine, they don't have anything objective to show that you're impaired. And those tests, they only become objective when you perform all 3 of them. If you perform any one of them or any 2 of them, the percentages drop way, way down on the probability of you actually being impaired. It brings me to my third point. Exercise your 5th Amendment right to remain silent. Courts have said you must affirmatively assert this right. You see people all saying, I don't answer questions, I don't answer questions, or just being quiet. Well, that can be used against you in a court of law, the I don't answer questions. If you sit there and say, I affirmatively assert my 5th Amendment right to remain silent, done. They can't bring up the fact that you wouldn't cooperate, that you wouldn't answer questions, or anything like that. That is constitutionally barred from coming against you at a trial. So let's recap this. The officer has pulled you over. You haven't provided any breath samples. You haven't done any field sobriety testing. And you have not admitted to drinking. You haven't said, I'm coming from Joe Bob's bar down there, heading to Peggy Sue's place over here, where you've had a couple at the bar. All that's not there. They don't have a leg to stand on. All they are going to have at that point is that the officer's going to say, I observed bloodshot eyes. I observed slurred speech when he told me he wanted to exercise the 5th Amendment right to remain silent, in which case your attorney stands up and says objection to get that tossed out if they're worth their salt at all. And they don't have anything objectively showing that you drank or are impaired. Once you have that test that says you blow a .08 or greater, as an attorney, I got to go and find a way to beat that test. If I don't beat that test, you're going to be found guilty of a DUI first offense under the Mississippi laws. There's ways to do that, but it is certainly another layer to your case, and you've got to go fight it. There's no ifs, no ands, no buts to it. And field sobriety tests, frankly, they're the easiest things to hammer on, simply because police officers mess them up just as bad as drunk drivers do. They don't show you the proper way of doing it. The officer doesn't give the proper instructions. I've seen them miscount the number of cues in a test. And when they do all of that, guess what? They're giving me ways to get those tests tossed out. But if you haven't blown into anything, you haven't admitted to doing anything, and you haven't done any field sobriety testing, well, makes life a lot easier for us on the defense side. Makes it a hell of a lot harder for them on the prosecutor side, doesn't it? My advice, heck no, don't blow. Affirmatively assert your Fifth Amendment right to remain silent. And last but not least, don't do any field sobriety test. Turns out I poured way more of this than was required for a video. So there may be more advice to this evening than advice, but more advice in the video than whiskey drinking.